welcome to SouFLoTV again, everybody. It's your host with the most, and today we're going to be talking about some immigration policies. So we're in 2019, and someone said to me recently, SouFlo, how come you haven't given us any update on anything as far as immigration goes, right? So I went and I did a little bit of research, and I gathered some information for you, which I have right here in my hand, and I'm going to read them to you. And this information was printed on the 9th of January of 2019. All right. So here are 5 immigration policy changes that will affect legal immigrants in 2019 in the USA. Now, legal, not illegal, legal. You're perfectly legal. You have your papers to be here. You're good. ICE is not looking for you, and if they encounter you, you will not be dragged off to one of the ICE places to be processed for deportation. You are legal with a L. Clarified? All right. So President Donald Trump aimed to reduce legal immigration and increase Department of Homeland Security authority to ensure the immigration laws are followed. He did that in 2018. That was his agenda. He wanted to decrease legal immigration, stop the flow of people coming in, basically, legally. Of course, he wants to get rid of those who are illegal here, and he wants to stop those who are illegal from coming in as well. But he also wanted to reduce the flow of legal people coming in. That was a part of the agenda for 2018. There are some changes and updates to immigration policy which are punitive by nature, while others aid foreigners in obtaining immigration benefits such as naturalization, permanent residency, and an extension of visas. So in other words, some of these changes, they are good, and some are, I don't know. Pay attention though, and you'll find out which one applies to you. Okay, I'm giving you 5, and these are the 5 major ones for 2019 that will affect legal immigrants. Now, let's start out with number 1. A new procedure for the issuance of notices to appear, or NTAs. When it comes to deportation, the DHS, or Department of Homeland Security, expanded the list of reasons that legal immigrants can be removed from the United States. They did that starting in June of 2018. So while you were busy partying away summertime in June of 2018, they were busy expanding the list of things that could make it so that you would become deportable. All right, basically, the updated list includes crime convictions and charges. So, crime convictions and charges. What that means is charges mean you don't have to be convicted. You just need to be charged. And once you are charged, you are in custody and you're charged immediately, because there was a time when local police, law enforcement did not work hand in hand with immigration. That changed. Okay? Now they work hand in hand with immigration. So if you're picked up, if you got some charges, it is possible that they could start a deportation proceeding on you, and you could be stripped of your, say, permanent residency and deported, depending on what that crime might be. I'm guessing. Charges, they've gotten real frivolous with the charges. I've even heard of people being deported and stripped of their green card for traffic violations. Yeah. Okay. So the list, updated list, includes crime convictions and crime charges, fraudulence, Abusing public benefits and denial of immigration benefits. So let's talk about fraudulence. Fraudulence is you fraudulently got your green card. You lied on that application. You said stuff that wasn't true. They found out years later. You could be stripped of your green card if they do a revision and find that lie. You could be stripped of your green card and deported, okay, or your status here and be deported. Abusing public benefits, not just your green card, by the way, for the fraudulence. You could be stripped of everything and be sent packing. Abuse of public benefits. We talked about this on other videos before. Abuse of public benefits is you're collecting benefits when you don't need to, kind of thing. Food stamps and all that other stuff. Abuse of public benefits. And denial of immigration benefits. That one speaks for itself. If you've been denied the right to stay here, then more than likely you're going to be deported, right? Number 2, USCIS can deny immigration application without initially warning the applicants. So back in the day, they used to have to warn you. They used to have to send out a warning that, hey, your application is going to be denied. If you don't do this, you have 30 days to submit this, and more proof that so and so and so. They no longer do that. Immigration adjudicators do not have to issue a notice of intent to deny or a NOID or request for evidence, or a RFE, which is a request for evidence, before denying applications for immigration benefits, and that happened as of July of 2018. Now the first one extending the list, notice that happened in June. It became law, right? This, they don't have to tell you anything. July. They were working very hard. June, July. All right. These 2 warnings afforded applicants and their lawyers more time to fix any errors that were in their paperwork, to gather more documents that would be beneficial to them, and so on and so forth, before the courts would make a ruling, or the officials would make a ruling. Now that has been stripped away. So if you send your paperwork in, this is how this is harmful. If you send your paperwork in, right, and they decided, hey, we're not going to approve this person, stamp denied, right away. They don't have to tell you anything. Hey, we can't figure out here, some information is missing. You need to submit this information to us by this date, and if you don't, then you'll be denied. That no longer happens. They'll just stamp denied. And you're sitting there waiting on your paperwork to come back, or they probably won't even stamp denied right away. You'll just sit there, wait for your paperwork to come back. Yeah, I've got my paperwork in process, and they've already started a deportation proceeding for you. And and you're waiting, okay, it should be back in 4 to 6 months. And 8 months later, you're picked up by ICE. And you're wondering, but I did all the proper paperwork, right? Yeah, but it didn't go through. Well, I didn't get a notice. Well, we didn't have to notify you, sir. It says it here as of July 2018 that, right? So that's another one to be aware of and to look out for. Number 3, increase the validity of Form I-693. All right, what is that? This form generally accompanies medical vaccination exam results necessary to meet federal health requirements to obtain immigration benefits. So as of, this one I think is good. So as of October 2018, see, July, August, September, October. So as of October 2018, the I-693 can now be signed by an approved doctor up to 2 months prior to filing an application. All right? I don't know who has to approve the doctor, but it can be done up to 2 months before. Whereas recently, it had to be done during the process of. Had to be fresh and new. Now it could be up to 2 months. Number 4, establish joint residence while married to become U.S. citizen. So, as of October of 2018, if an immigrant spouse wishes to obtain U.S. citizenship, he or she must remain married to that U.S. citizen and must cohabitate for at least 3 years before applying for naturalization. If the marriage ends before that 3-year period, he or she can never apply for U.S. citizenship. Did you get that? All right. And what they were trying to do is, see, a lot of people come in, and what they do is, I'm going to find me a citizen, and I'm going to get married to the citizen. I don't even like the person, but I'm just going to get married and stick it out long enough to where it gets to, and then I'm going to get all my papers right, and then I'm going to leave his ass, or I'm going to leave her, and I'm going to bring my other people over. Because that's one of the rights as a citizen of the United States of America, is that you can bring other people over, providing you're in a position to do so. You can bring others over from other countries, right? So people come and they do it under false pretense, and it's not a real marriage. They've long gone past the let's fake like it's a real marriage. It's a deal. All right. I'm going to leave some shoes, couple of pieces of clothing over at your house. So just in case they check, you just say, I'm out, I'm at work or something. Here's my information. If they ask what my favorite color, people rehearse and really put work into making sham marriages look real. So with that, they counteracted that by saying that you would have to be married for a minimum and cohabitating for a minimum of 3 years before you can even apply. And if that marriage ends before that 3 years, then there's no way on earth you can apply. Point blank, period. And number 5, the interview for green cards through marriage can be waived. So you see, that one was kind of, because what if you're stuck in an abusive relationship, right? Married somebody and then you found out, oh, they brought you over here to wash, cook, and clean, not further yourself in any way. You are to be my slave, and you owe me for bringing you here. So you do as I say when I say do, and you're like, oh man, but I want to get out of this. Do I have to just go back to where, after giving 2 years of my life, I got to go back home and start over? I packed everything to come with you kind of thing. People could be stuck in that kind of a situation, right? Now, this one says the interview for green cards through marriage can be waived. So in order to upgrade from conditional residency to permanent residency due to marriage, conditional residency. Conditional residency means under these conditions you are allowed to stay here. You're not even a, say, green card holder. You're like a temporary green card holder, which would give you the right to work here, and they can collect taxes off you and so on and so forth. The right of citizen, but not the right of resident or legal resident, but not all the rights afforded to a citizen, right? So the interview for a green card through marriage can be waived. So in order to upgrade from conditional residency to permanent residency due to marriage with a U.S. citizen or a legal resident, couple must first be interviewed by USCIS officials to determine the validity of the marriage. And this often made people very nervous. That was how things have always been done. But as of November of 2018, see that? June, July, August, September, October, November. As of November 2018, if there is enough evidence proving that the marriage is authentic, immigration adjudicators may waive that interview. So it was mandatory before to go through that interview. And a lot of people were legally married, really living together, and still had to go through this. And they're like, look, we've been together for 5 years now. We've been sharing the same bank accounts for 5 years. Both our names are on the lease for where we live. We have children together. I drop them to school in the morning. She picks them up in the evening. The teachers know both of us as parents because we attend parent meetings. Their doctors know both of us because either I take the kids to the doctor's appointment or she does. That if you can come up with that list of provable that that's what it is and that's what it's been, then they will waive that interview and go ahead and just issue your proper papers, right? But if you cannot prove that, then you're going to have to go do the interview just the same. So that's it for now. And what I just gave you were the 5 policy changes which will affect legal immigrants for 2019. It's SouFLoTV, man. Like, comment, share, subscribe. Leave your comment in the comment section below. Let's talk about things there. All right?